Well, Magistrate Elliott, so glad you're here. I know we've been working on getting this scheduled here for a couple months, and would love to dive in, learn a little bit more about you and probate. Actually, this is a question that have in my head between a judge and a magistrate. What is a magistrate?
I can tell you that I get that question all the time.
Really? Okay.
What is a magistrate?
Right.
What is chief magistrate? Because
Okay.
that's my title at the court is chief magistrate. So I think the best way for me to tell you what a magistrate is kind of give you a personal story of how I told my family. Okay. So I was a practicing attorney, as you know, as we talked about, for about 15 years. And I went home. Judge Stormer called me and asked me if I'd like to be a magistrate in her court. So I went home and I said to my kids, I'm not going to be a practicing attorney anymore. I'm going to be a magistrate. Do you know what a magistrate is? And they all just looked at me like I have no idea what you're talking about. They were all teenagers and younger at that point. And so I said, well, Judge Stormer, she's our elected probate judge here in Summit County, and she appoints magistrates to basically help her with the caseload. We have 4 magistrates at the court. I'm chief magistrate. I was promoted to chief back in January of 23, so about 3 years now. But she has 4 magistrates that help her. I said, so what that means is she is the judge, but I wear a robe. I sit at the front of the courtroom. I have hearings. I've had trials. I issue decisions. I have my own caseload. I do everything that she does, but we do it for her. She's the boss. Great. And so my daughter at the time said, so you're a mini judge. so if you think mini judge, you'll always remember what a magistrate is.
Okay, great. So it's an appointed role. It's not one there's not an election for it per se. Judge, yes, election. However, magistrates are appointed by the judge.
That's correct. Yep, appointed by the judge. And it doesn't matter the court. The judge is basically who picks the magistrate. It's a little different in the federal system, but here in the state system in Ohio, judges pick who their magistrates they would want to be their magistrate, and you serve basically at the pleasure of the judge.
Okay, great. So your background started, you mentioned private practice. Prior to that, you were in the CIA as well.
Yep.
So what about the CIA private practice has prepared you to be a chief magistrate today?
Yeah, I get that question all the time because it is kind of a weird background to end up in probate court, especially. Right. People say, oh, you had law enforcement. Were you a criminal defense attorney? Are you in criminal court? No. But I think my background has definitely prepared me to do what I do now. In law enforcement, as a parole officer for the state of Ohio and as an officer at the CIA, it exposed me to people from a lot of different backgrounds. And during that time and in those roles, it helped me realize that people come from different places. People have different levels of understanding. People communicate differently. As an officer in both places, I had to communicate with offenders, people in the public, their family members, counselors, judges, attorneys, and being able to effectively communicate with all of those people in that role has prepared me for what I do now. I see all of those people now in my role as a magistrate. I'll have somebody, who may have a criminal background in front of me, along with an attorney whose family member died. And how I communicate with those people based on their background came a lot from that law enforcement side. Being able to hone my skill on the law enforcement side there has definitely helped me enroll as magistrate. And I think in private practice, not every judge or every magistrate has been in private practice. It just doesn't always happen that way. But that has helped me immensely. I had a general practice, so I did some criminal work. I did a lot of real estate work, and I obviously did a lot of probate stuff, guardianships and estate administration and estate planning as well. I've sat on the other side of the bench. I sat in the probate court and made arguments and talked to the magistrate on behalf of executors, next of kin, guardians, and wards. So I've actually been there. I know what people on that side are going through, whether it's the attorney or the client. And I think having that background, it has allowed me to empathize with people that are sitting there and know they're in a situation they didn't ask for most of the time. Right. A family member passed, or they need to get guardianship of their mom, or someone's trying to get guardianship of them. They didn't ask for any of those things. And what people are looking for a lot of times is to be heard. And have somebody listen to what their case is and listen to what their issues are, and then make a decision. So I think that experience has helped me immensely, having sat in that seat and done those things. I know what they're feeling.
Yeah, that makes a lot of sense. You don't think of, when you think of like law enforcement, most people don't think of the need to be great with people, to be very relational, right?
Right.
Yes, there is law. Yes, there is a yes and no, black and white part of this, but you're dealing with people. And at the end of the day, that's like helping you prepare to deal more with people.
Exactly.
And give you more exposure to different situations, scenarios, and
Yep, great. Exactly. And being in a position of authority, because you are
right.
in law enforcement, just like you are as a magistrate.
Yep.
Understanding that just because you're in authority doesn't mean you just tell someone what to do and they do it.
Right.
Being able to communicate with them, find out what they're feeling. Yep. And I took the approach as a law enforcement officer, in most cases, not obviously and not all, that communicating with somebody, finding out why it is they're in that situation or what happened or what they did, oftentimes help them get the help that they needed to not do it again.
That's right.
Or to stay out of the system. So that's kind of the approach that I took when I was in that seat as well.
Yeah. So fast forward to today, Summit County Probate Court. As a curious citizen, right? What is probate court? What is the probate court?
That's another question.
Okay.
We get all the time. What is probate court, and why should I care about it?
Sure,
right.
Right.
When people hear probate, you immediately think death, dying, the process of dying, end of life, maybe guardianships or incompetency. That's immediately what people think about.
Yes.
We like to say we're way more than that. We say we're the court of new beginnings and endings.
Okay, what do you mean by that?
Yeah, we handle over 200 different kinds of cases at the probate court. I always make the joke, if the legislature wasn't sure where to put a case, they stuck it in probate. So new beginnings and new endings. We issue marriage licenses. So if you were married in the state of Ohio, you went to the probate court to get your marriage license. Start of a life with a new spouse. We finalize adoptions. Most people don't know that. Start of a life with a new family. We finalize all name change hearings. So if you want to change your name, you file the application with us, and we're the one that grants that, starting a life with a new name or a name that suits you, that you want to have. And then obviously the things you think about, guardianships, estate administration, trust law, basically anything to do with passing property to someone, or if someone's incompetent, like guardianships as well. So those are the end of life, new beginnings, all of those things, and then the endings are things that people traditionally think about.
Great.
We have weird cases too that we handle. We handle civil commitment hearings. So if somebody has a severe mental illness and they're off their medications and they need help, maybe need to be involuntarily hospitalized to get the treatment they need, we're the court where that happens. The case is filed with us and we make that determination. Should the person be put in the hospital to get treatment? We do disinterment and reinterment cases. So if you need to move somebody's remains, that case gets filed in our court. We also handle protective order cases for older adults. So if there's an adult that's an adult over 60 in Ohio is considered an older adult that's been abused, neglected, or exploited, that case is filed in our court, and we would have a hearing to try to get the person out of that situation. We handle eminent domain cases, just a wide variety of cases. I could have an adoption in the morning, a guardianship late morning, and a state case in the afternoon, followed up by a name change.
Wow.
And we have to be able to shift from thing to thing. The common thing, the way that I like to tell people is all of those cases that we just talked about, those types of cases, is helping someone through something. Sure. At the Summit County Probate Court, we help people, and that's the approach that we take.
That's great. Is Summit County different than other courts, or do all probate courts in other counties do the same kind of new beginnings?
So I'll be careful here. No.
Okay.
They say, and if you're part of the probate world, they'll say there's 88 worlds of probate in Ohio with the 88 counties. Obviously there's a set of laws that apply to all probate courts throughout the state, and those have to be followed. But each court has their own local rules and their own local procedures. So how you handle a guardianship case here in Summit County, it's probably different than how they do in Cuyahoga County. We follow that, that umbrella of the statutes, but each of us have different procedures and different local rules that you have to follow.
Mm-hmm. That's helpful. I've heard on the street in talking with families that and other attorneys that Summit County Probate Court is great. And so that's the opinion that's out there, unprovoked. But that is what we hear, that Summit County is a very good probate court. So congratulations to you and the team and Judge Stormer.
Well, thank you. We
great.
Appreciate that. And I think that I think that Judge Stormer has transformed this court into that. I mean, honestly, and I don't just say this because we're sitting here, we honestly take the approach that we want to help people through these difficult situations. She's kind of fostered that attitude in the court, and for the last 7 years since I've been there, I'm happy to be a part of making sure that that continues, and making sure that we continue to have that reputation.
That's great.
We've heard that a lot from practitioners and people, that have had situations in different counties, and we take pride in that, and that's definitely something that we want to continue, now into the future.
Mm-hmm. You mentioned helping people through difficult things. As a family, we've been able to be impacted through adoption, and we've been impacted. People are like, "Oh, that's great that you're adopting these kids." I'm like, "No, they've helped us way more than we can help them." But they are very difficult situations, and some of the most gratifying and relieving times for us is when the adoption was final. And we were able to stand in front of the probate judge and or the magistrate. Mm-hmm. I'm now looking back. I'm like, wait, was it a magistrate?
Was it in Summit County?
It was not.
Okay.
These are one of the other 87 counties.
Gotcha.
Yeah. So Cleveland, Columbus, and Cincinnati areas.
Gotcha.
For us, it was a wonderful experience, but it was a lot of hard work to get there, and it was a difficult situation. And then when it happened, it was like, this is beautiful. It was a beautiful moment. Yeah.
And
right.
I mean, and that's, I'm glad you brought up adoptions. I know we're not necessarily here to talk about that, but adoptions are my favorite cases.
Oh, cool.
Obviously you have situations where, these kids chose this family, or, the parents chose to make this permanent. And you're literally, I finalized an adoption a couple of weeks ago. It was an adult adoption, which are one of my favorites as well, because you have an adult person saying, I want this person to be considered my mom or my dad. And, there's nothing more touching than that, right? Like, this person raised me. I want them to be recognized as my parent. And the girl said, the young lady said, I should say, she was 19. And she said, blood doesn't make family, love does. And in the adoption world, I think that's absolutely true. And it's gratifying, and one of the most fulfilling things that we do is finalize adoptions and help make that family complete. I mean, we love that.
That's great. Yeah, we loved it too.
We always make that final hearing a celebration too.
Sure.
We always make it happy. We do, the smallest amount of legal stuff we have to do because we want that final day to be a celebration. We usually have the kids take pictures on the bench holding the gavel and, just kind of celebrating. So it's a great day. I'm glad you were able to experience it.
Yeah, it's been nice. I know we have to shift back to the reality of,
right.
Passing life, right?
I'm going to pause you right there for a second.
Okay.
I want you to look as best as you can. I want to have you hold
Yes,
your
I keep
chest
doing that
down.
too to try to keep it down.
Yeah, because it looks like your vest is a scarf on.
Oh, really?
All right, cool.
Thank you.
Well, thanks, Tim,
Yeah.
for keeping us straight. Now, where do I start? Just to start with a random question?
Just keep going.
Okay. So we hear about avoid probate at all costs, right? That's again, it's what people think in the community. But what do most people misunderstand about probate?
Everything. No, I'm just kidding. One of the things that we do at our probate court that I think is unique, I believe some others do it as well, but we have a community outreach program with us. And one of the things we do is we go around the community and do presentations.
Great.
One of those presentations that we do, and I do most, if not all of them at this point, we call it Probate 101, where I go around and I'll do presentations for small groups, church groups, Rotary, whomever it may be that's interested in having a group of people hear what probate is, what we do. And I do those presentations. And I usually open with, how many of you have heard or said, I want to avoid probate? And every hand in the crowd goes up. Yep. And so my follow-up to that is, why do you want to avoid probate? And that's where it gets a little shaky, because people go, well, I don't know, that's what everybody says, and I hear it's a bad place. I don't want to be there. And so the three main things that we hear about I want to avoid probate is, I don't want to pay the taxes,
Okay.
the amount of time that it takes for a probate to work its way through, and the cost. And so then I'll talk about each one of those as to, how is that maybe true or not true. So I always say, when I was in practice, when I was doing estate planning, the first thing people said to me was, I want to avoid probate, don't I? And my response to them was always, it depends. What do you have? What is it you're trying to do? Who are you trying to leave it to? What other things do we need to think about? So should you avoid probate? Maybe, maybe not. It depends upon your situation. And then I'll talk about like taxes, for example. People think that if you have property in probate, you pay more taxes on that property. And that's not true. In Ohio, we no longer have a death tax. People call it a death tax or a state level estate tax. We used to. We did away with that at the end of 2012. So now the only thing you have to worry about is federal estate taxes.
Okay.
On the federal side, I think this year you can pass $15 million tax-free. So anything above $15 million, you're taxed on the federal side.
Okay.
So taxes are something that, people think, ooh, if I don't go to probate, I don't have to pay taxes. Well, you're probably not going to have to anyway.
Okay,
You're not
good.
taxed on an inheritance. It's not income. It's not treated that way. Time, I know that's a big topic, and we'll probably talk about it more, I'm sure. The amount of time to get a probate through our court, average 6 to 9 months, somewhere in that ballpark. 12 months, depending on the property. There's real estate involved. Are there creditors? Are the beneficiaries fighting? Obviously, that can take some time. And a reason that I'd say probate court might be a good thing is when it comes to those fees and attorney's fees. For example, in an estate, if an attorney's trying to get paid in the Summit County Probate Court, we look at their bill. What were they billing hourly? How much did they bill? What did they do? Is this fee reasonable before we say, okay, you're allowed to get paid that money? So we actually are kind of a safety net to make sure that those things are done and done properly and not overcharged for. If all of the beneficiaries say, hey, we hired Steve, he did a great job, we're okay with him getting paid this, then we don't review it. If everybody's okay with it, then we say, okay, fine. But if not, we're there as that safety net to make sure that they're treated fairly.
Okay. Is there a standard rate that attorneys get? I mean, do you say, okay, not you, obviously, does the court say this is what we'd be charging per estate? Is there a percentage or is there a fixed rate? How does that work? So for families that they're looking at this, like how much does this cost? Is there a ballpark that you tend to give families?
No, it's a moving target. Okay. And that goes into the 88 worlds of probate here in Ohio. Some counties have percentage-based fees.
Got it.
We don't follow that. We follow an hourly billing and look at what the attorney bills per hour, make sure that that's reasonable. In each area, things are different. An attorney in New York can charge $600 an hour, without blinking an eye. Here in Akron or Summit County, that would be outlandish.
Sure.
So, it depends upon the area. We look at how long has the attorney been practicing? What's their experience? Do they do a lot of probate? Was there something in this estate that required, a certain level of expertise? All of those things come into play. In our court, we look at an hourly fee rate.
Mm-hmm. You mentioned a couple big questions that you tend to get, but are there, any common questions you tend to get on almost every case? I know you mentioned now over 200 different
right.
cases that come through a probate court, but are there common questions that you tend to get in an estate?
Yes.
Or in a probate administration case?
Yeah, I think so. We have a lot of people that don't hire attorneys to probate an estate. And when we have cases like that, one of the other services that our court offers that a lot of others don't is we call it a pro se hearing. Person's not represented by counsel, they're representing themselves. That's called pro se. So we have them come in for an initial hearing. I'll sit down with them, one of our magistrates sits down with them and goes through what the estate process is. Here's what you have to do to start, here's the next step, and so on throughout the whole process. And I think when we sit down with people, some of the common questions that I get are, well, Dad always told me that I was going to get the house. You're telling me I'm not. Why? And then I have to explain, just because your dad said it doesn't mean it's so. In his will, he said this is what controls. Or he didn't have a will, this is what the statute says, who gets your property. That's a big one. Well, Dad said this, why not? Another one is, well, Dad had a will, why can't I just split the property up like the will said? Why do I have to file things here? And then we just have to explain, we didn't make that rule. We just have to enforce it. The legislature says you have to file the will, and the probate court monitors and make sure things happen how it's supposed to. So that's why you have to do it. Those are some of the common questions I get, or more of that, on a personal level. Hey, why is this way?
So when someone's doing pro se, or is it pro se?
Mm-hmm.
Okay, when they're doing pro se, is that, I don't want to say dangerous, but are there things that people should look out for? Because unrepresented, I would think going into a legal situation, there's money involved, there's a court involved. I would want to make sure that I'm kind of protected, if you will. But I mean, on a simple case, is it people can do this, and is it? Would you guys recommend that for folks to kind of on a simple estate? Would it make sense for them to go in?
I think it can.
Yeah.
And like I said earlier, I think every situation's different. But we have people that successfully navigate the estate process without an attorney all the time. So it does happen quite a bit, and it is something that can be done. I'll be honest, there's times I've sat in a hearing, that pro se hearing I was talking about, and said to somebody, you need to hire an attorney. You can have sticky issues with investments or stocks, real estate that I know we're going to talk about later, that issues with certain issues in real estate that you're going to need counsel to help you through it. And there are dangers. If you are the fiduciary of the estate and you don't do something right, you can be held liable for that. So there is some personal liability that could arise out of something if you screw something up. But we take the approach, if somebody wants to be pro se, they don't want to pay an attorney, that's up to them. We can recommend you need an attorney, but if they proceed forward, then that's their choice. We treat them as we would treat an attorney. After that initial hearing and we go through the process, you have to do it. You can't call Magistrate Elliot and say, hey, this is what's going on, what do I do? I'm not allowed to give you legal advice. On a one-on-one situation, I can talk, things like this and help people with questions and things, but one-on-one, I can't say, Mr. Executor, here's what you need to do. I'm not allowed to do that. So after that initial hearing, you're treated just like every other attorney. But we have a lot of information on our website to help people through it, explanations, what forms you need, all of those things. And then one of the other things we have an attorney help desk. So if you have a small estate like you're talking about, you can make an appointment with our attorney help desk, where we have a local attorney that meets with somebody for half an hour, can answer questions for them, help them fill out forms, whatever issues they might have going on in the estate, and kind of walk them through it. So we try to help people if they want to make that decision to do it themselves. So we offer those services just to try to make it easier for them.
That's great. That's great. You mentioned complex estates, a lot of like businesses, stocks, real estate. So those can be complex estates. However, we see like people tend to be the toughest thing, right? Expectations of the family, of the heirs, saying like, well, there might be three siblings that now are part of the estate. We'll dive into this a little bit, I hope. But like, what are some common disputes that you see in the probate court?
You're kind of hitting on them, I think. I don't know if you've ever heard the saying, if there's more than one person in your family, it's probably dysfunctional. So we run into that quite a bit in the probate court. You have families that have gotten along forever, and then money's injected, or a business is injected into the situation, and it just turns difficult. I think that, and again, we'll talk about this now, I know more as we go, but communicating with each other is a huge way to try to avoid some of those things. We all know that there are people that are just going to be difficult because, that's the world they live in, or they think they're entitled to property. And so they're going to be difficult, and they're going to be difficult throughout the whole process, and it is what it is. But to me, just trying to minimize those things with communication. I'm talking outside of court now, with communication with each other and things like that, I think help. But I think probably one of the most common issues that we'll see in an estate is when, brother is the fiduciary and you have a couple other siblings. And one of the things you have to do in an estate is file an inventory that shows everything that's going to go through probate. Inevitably, one of those beneficiaries say, well, hold on a second, Dad had that coin collection. Why isn't that here? Or Dad's car's not listed. Dad had gold bars in the basement. Why are those things not there? I think it's like transparency issues, I guess I would say. There's always, especially if there's some tension between the family, it's, I don't trust him that everything's there. And I think these things should be there. We see that quite a bit. And then issues with like distributing property and paying bills and things like that. Hey, he's not doing what he's supposed to do. And then another thing that happens a lot, and I'm sure you've seen this in your business as well, people think that personal property is worth a lot more than it is.
100%.
Well, hey, Dad and Mom paid 10 grand for that dining room set. Why are you selling it for $1,000? And people, especially in tense situations, think the fiduciary is not doing what they're doing. They're not being transparent. This should have been sold for more. I think that's probably the most reoccurring theme that we see when people aren't getting along.
That's hard.
Yeah,
it's hard. It's so much emotion there and years of thoughts that just just like culminate right there at the moment. But also with family structures, they're so complex nowadays. It feels like with different, even with adoptions and or divorce and or those types of situations, it gets pretty complex. But what challenges do you see today with these complex families and estate planning? You mentioned communication, prepping, planning, but getting into some things that people do pre-death, in preparation for these things. With complex family situations, is there a new way to do estate planning?
Great question. And I think the complex family situation doesn't necessarily make the estate planning more complex. I think if you don't have the estate planning, it gets really complex.
Okay.
There are so many different tools at a planner's disposal nowadays. You have, wills, trusts, transfer on death, payable on death vehicles that you can use, LLCs. I mean, there's so many different things that a planner can use to help try to minimize issues, especially, we always say a blended family situation. You have kids from a prior relationship, you're married to somebody who's not the parent of the children, or if you're in a long-term relationship with somebody but you're not married, same-sex couple maybe that's not married. If you don't have planning in place in those situations, that's when things really get complex. People just think, hey, this is my significant other, they're going to get my estate. Well, if you don't have a will and you have a blended family, or you are not married to your partner, that's not what happens. You have a blended family, your spouse gets, if you don't have a will, your spouse gets a percentage, the kids get a percentage. You don't get to pick what that percentage is, it's in the statute. So if you say I want my spouse to get 50% and my kids to share the other 50%, if you don't have a will or a trust or whatever that says that, that's not what happens. So the lack of planning is what causes the complexities. Obviously, that situation requires more planning than, a husband and a wife that doesn't have kids. Obviously, that estate plan is going to be easier. But I think if you go see an attorney who does estate planning regularly, they can walk you through that process and make it less complex when you're not there.
Mm-hmm. Makes sense. You spent so much time helping people establish plans for their estate, and you see these being executed in the probate court. But between all the different types of wills, power of attorneys, transfer on death designations, payable on death designations, beneficiaries, which tools have the biggest impact on a family? What are the things they have to do? Which ones are the most impactful for a family in planning?
Ooh, that's a great question. If you made me choose,
okay,
I think I'll break these into two different things.
Okay.
That makes the most sense to me.
Okay.
Powers of attorney, and I'll add living wills into that. We'll call that. Those are the things that I think to me are the most important, because those things, powers of attorney, you choose somebody to make decisions for you, whether it's healthcare or finances. Two different documents, by the way, for those two things. But you choose who you want to make those decisions for you if you're not able to. So you picking who it is you want to make those decisions is important, because you're still here and they're deciding what happens to you. So I think that power of attorney, and then the living will document, some people might not know what that is. That's a document where you can say, if I'm in a terminal condition with no chance of recovery or permanently unconscious state or brain dead, I don't want to be kept alive artificially. Don't put me on a ventilator. Don't give me tube feedings. Allow me to pass away naturally. Those, I think, if you said to me, what's the most important, I'd probably say those two things, because it's you saying what you want to have done. And you're still here. So taking care of you, to me, makes it more important than taking care of your property. So if you said to me, if you can only choose two,
there you go.
those would be the ones that I would say,
Okay.
because it's you choosing, you letting the world know who it is you want to make those decisions for you, and you're still here. On the estate side, so after you pass away, that's where we talk about the wills, the trusts, the transfer on death and payable on death things. Transfer on death and payable on death vehicles, those are things that help us avoid probate. So do you want to avoid probate? Those are tools that you can use to avoid probate. So you can use a transfer on death or payable on death on, for example, checking accounts, savings accounts, 401ks, IRAs, 403bs, mutual funds, anything, life insurance, anything you can designate a beneficiary on is a TOD or a POD. And then when you die, whoever you have designated in those instruments, that's who gets that property. So if I have a life insurance policy and I designated you to receive that property. Now my will says my wife gets everything, and if she's not here, then my 3 kids get it. But I have you listed as the beneficiary on that life insurance policy, you get it. So it doesn't matter what your will says. If you have a beneficiary designated, that trumps what's in your will. So I always tell people, make sure you know who's on those accounts, and that's who you want to be there. Make sure it's updated if something happens in life, so that the person that's going to get it gets it. And it happens a lot quicker. I talked about that 6 to 9 months in probate. If you have a beneficiary designated on that life insurance policy, once they have the death certificate and they fill out the form that the company requires, they get the check. It might take a week or so, but it happens a lot quicker. So those transfer on death and payable on death instruments that have really become more common, I'd say in the last 10 to 15 years, are a huge part of estate planning, and definitely something that if you have a plan, you want to talk to your planner about to see if it's something that you want to incorporate if you don't have it already.
So help me understand, if I just got a couple questions around that.
Sure.
One is okay, if I'm creating this plan, how about this? When is the right time for someone to create an estate plan?
Now.
Okay. Well, so I look at, either their children, they're single, they're about to get married or something, should, is that a good time? Or when you're, I agree, now, have a plan.
Right.
Yeah.
Right.
And from what I understand, only 35-ish% of people have a plan in place.
That's probably about right.
Mm-hmm.
Yeah, if I had to guess, I've never researched that, but that's probably about right. To me, having a plan it's not age dependent, especially when we're talking about the powers of attorney and living wills.
Okay.
Because once you turn 18, you are your own person. So if my son, for example, God willing, nothing like that happens, but if he's at college, something happens, he's in an accident, and he needs a decision maker, if he didn't have a healthcare power of attorney, I would have to get guardianship over my own son to make those medical decisions for him. So he's 22 and healthy and, doesn't have issues, but if something does happen to him, if he didn't have that power of attorney, then I would have to apply for guardianship. So I think especially with those documents, now is the time. If you don't have them, get them. If your kid is 18, have them get one done to try to eliminate that from becoming an issue. And then same with wills. And it's easy for me to sit here and say, get a will now, right? I was an attorney and I had my second kid before we did our wills the first time. So it's easy to say, get it done and do it. The difficult part is people don't like to think about it. People don't want to think about, their own death or what happens if I can't make decisions for those are dark things that we don't want to think about. But it's very important to have those things, whether you think you have a lot or you don't. And an example that I'll use is, maybe you don't have a lot of stuff now. What if when I'm leaving here today, I get hit by a Coke truck and it was the Coke truck driver's fault?
That's not gonna work.
Right?
Right.
Now all of a sudden there's money, in the estate. And I would rather have you decide, or I would rather have me decide where my money goes, and I want you to decide where yours goes. So have that will, just in case. Very important if you have children under the age of 18 to have a will as well. Because one of the things you can do in a will, it's not just who gets my stuff, it's who gets my kid. You can name who you would want to be guardian in your will. as well. So if something happens to you, you pick who the child's guardian would be, and that's who we would appoint then most of the time to be guardian of the child if something happens. So I'll stick with my answer is do it now.
Okay. So that was the other question. The second question of that, like financial advisor, planner, estate attorney, what's the right person to use in those situations? Should someone use an estate planning attorney or should they use a financial advisor?
So
what limitations?
So remember, I'm an attorney.
Yep.
To me, when it comes to strictly estate planning, well, let me back up. Ideally, in the approach that I took, it's a team approach. When I was in practice, if somebody had a financial planner, I didn't want that financial planner not knowing what the estate plan was, and I don't think the financial planner wanted me to try to do estate planning not knowing what their financial plan was. To me, it's a team effort that everybody needs to be a part of. When it comes to the powers of attorney, I think an attorney should guide the person through that to let them know what the pitfalls may be, what the risks are, why you need to have one. So I think that especially with that and the actual drafting of the will, if you're not an attorney, it's actually the unauthorized practice of law. So an attorney is the one that's supposed to do those things. So I say the attorney. However, the more communication and the more teamwork makes that plan work and makes it more effective.
Makes sense. Yeah. The way our situation worked is I was working with a financial planner who then brought me and introduced me to the estate planning attorney, and we created the documents there on that side. So they did work together as a team. That was good synergies.
Yeah.
Yes, that makes sense.
Yeah, it's great to have that and have that relationship. And I know oftentimes attorneys and financial planners have that relationship with each other. I had that relationship with some financial planners, people that I trusted, we're gonna treat my clients like I did.
That's right.
And if I could refer them to somebody, if they didn't have somebody, then, again, to me, it's always gonna be a team approach when it comes to things like that. So have everybody involved if you can.
So all the great planning in place, you get all this stuff. Well, then but then people still go to probate, right? Or they still can go to probate. So what situations make probate unavoidable? Even with the best planning, what makes them unavoidable?
Right. Well, like we mentioned earlier, if you don't have things set up as transfer on death or a trust in place, you have to come to probate. Yep. Things that are titled, especially house, car, trailers, RVs, any of those things that are titled, they have to come through probate to be transferred. So if you just have a will, and I don't mean that in a negative sense, but if you just have a will, you have to come to probate. And also, the saying, anybody can sue anyone at any time for anything, you could have the best plan in place. And if somebody wants to file a lawsuit, to just say, well, Dad wasn't competent when he signed the will or the trust, or, he was under duress when he signed it, that can always happen. Now, whether they're going to be successful or not is another question. But I think if you have a lot of family discord, you can have the best plan in place and still end up there. Mm-hmm. And again, that's probably 1% of all of the estates that come through our court, 2% maybe, that are like that, but it can still happen. To me, having that plan in place and knowing, hey, this is what Dad wanted, sometimes that's enough for people not to fight over it. Not always, but sometimes it is. So I think that, you could have the best plan in place, and if somebody's difficult, you still end up there.
Yeah. I want people to understand, too, that probate court is not punitive. This is not like a criminal offense. You're not going to get judged. You're not going to get any kind of punitive consequences or anything from going to probate. It's a good thing. This is helpful. This is lays it out and makes sure everything's fair and done according to the decedent. So
exactly, and that's the message that I always want to convey to people when I'm out in the community or here is, we're not here to try to trap somebody. Yeah. We're here to make sure that what the person who died, what they wanted to have happen, is what happens. Mm-hmm. The intent of what that person wanted to have done, I want to make sure that what they wanted happens, because they're not here to speak for themselves. That's the reason we exist, to make sure the person who can't speak for themselves has the help that they need, or their stuff gets to where it needs to get.
Have you seen families be almost surprised when I don't know what the right thing is. A family comes in probably like a little nervous or something, like they don't know what to expect. They file probate. Like, what can a family expect? Like, what's that experience like? Is it good? Is it bad? Is it like, How does that feel for them if they're coming in?
I'm going to say it again, it depends.
Okay. Yeah, okay.
Obviously, the dynamics of that family matter a lot.
Sure.
And I can say in our court, we're going to do what we can to make it easy, or as easy as we can. So it's always intimidating, I think, for anyone that's not accustomed to it. I mean, since 2003, when I was licensed, I've walked into courthouses, so it doesn't bother me because I've been there a lot. A lot of people, the first time they have contact with somebody in a robe is because their parent passed away. So it's intimidating to walk in there. It's intimidating not knowing what's going to happen. It's intimidating not knowing what the law is. And I think all of those things add pressure and anxiety to that person. And what we want to do is try to eliminate as much of that as we can and help them through the process. Now, obviously, there's times where, if a fiduciary steals money or a guardian, is not making proper decisions, where we do have to take action that may be considered punitive. But again, it doesn't happen a lot. But our goal is we want to make it as easy and as quick as possible for the people there, because they're going through perhaps one of the worst days of their lives. So we want to try to make that as easy a transition as we can.
That's very helpful. That's good to know, that approach, for families. We hear in the marketplace this common theme of a race to the courthouse. We've heard stories about so-and-so, my ex-husband passed away, and, our children race to the courthouse to file probate. Like, in the court, I guess you guys don't see this necessarily, the timing. Can you speak to this at all, this concept that exists out there, and how does the court see this?
Great question. And a lot of people do think that. They think I better get there and file before, whoever it is does, because I don't want them to be the one in charge. We don't care who files first.
Okay.
There's a statute out there that says who has priority to serve as fiduciary. If you're named in the will, you have priority to be named the executor. So you would come first before somebody who's not. You come before the person who's named second. Doesn't always happen that way. If the person who's named first isn't suitable to serve, then we can look to appoint somebody else. For example, if they have we talked earlier, they have a theft in their background where they stole money, or, they were previously appointed and they took money, things
Probably
like
shouldn't
that.
be a fiduciary.
Probably shouldn't be a fiduciary, and we're not going to appoint you. So there are times where even where the will says that it doesn't happen. And there's a statute as well. Statute says surviving spouses first, priority, and then next of kin come after that, so kids, grandkids, etc. So if two brothers are racing to the courthouse and you beat your brother there, that doesn't mean we're going to appoint you. Okay. Whoever gets there first, we have to give notice to all of the other next of kin anyway, and then they have an opportunity to object to that person being the one in charge or being the fiduciary. So the race doesn't matter. Okay.
So we've heard of debtors also potentially filing. And is there something there too that like a debtor can file? But again, each case is individual. But in the masses, like how often are debtors trying to be the administrator of an estate? Creditors, you mean? Yeah, I'm sorry. Creditors.
It happens a lot, actually. In Ohio, the statute says that a creditor has to file a claim within 6 months of the person's death. Okay. So 6 months from that person passing, they have to file a claim in the probate court or serve that claim on the fiduciary. So what a lot of people do is if somebody passes away, they'll wait 6 months before they open the estate. Because if there's not a fiduciary appointed, that creditor can't serve their claim on the fiduciary because no one's appointed. So if people are delaying, intentionally or not, sometimes people, their mom just died, they're not going to rush to the courthouse to open the probate estate. They're dealing with things, obviously, other than worrying about what's going to happen to the stuff, and they just don't do it quickly. But if the creditor is a sizable creditor, a lot of times nursing homes, for example, if somebody was in a nursing home and they're owed a large bill, they'll apply to be appointed. It's called a special administrator. Okay. So whether there's a will or not, if there's not an estate open and you're a creditor and someone owes you money, you can open the estate to serve your claim on the fiduciary. And it happens several times a month, I would say, in our county. I'm sure bigger counties it happens more often, obviously, and so on. But it does happen where a creditor applies. And usually what happens is they'll apply. We'll appoint them special administrator because the statute says we have to. They serve the claim on the fiduciary. Usually they'll have an attorney apply, and they'll serve their claim on the attorney. And then the family gets notice of everything. Then the family comes out and says, well, hold on, here's the will. I'm actually the executor. So then at that point, we appoint them executor and terminate the special administration. But the claim remains valid because it was filed within 6 months.
Got it. Yeah.
So kind of a complicated situation.
It can
but
be.
Yeah, that 6 month time frame definitely can be a detriment to creditors. Because first they have to find out that the person passed away, which obviously nursing homes know, but credit card companies don't often know. Other types of creditors might not know until the bill doesn't get paid for a few months, and then they go, wait a minute, what happened?
And time flies too.
It
You're
does.
like 6 months actually isn't a long time.
It's not as short.
It feels like a long time, but
Right.
for a creditor maybe. But I look back and just my mother-in-law, who lived with us for a decade, she just passed 6 months ago, and
Sorry
it
to hear
feels
that.
like it was just very, very recent. But it
Yeah.
also just that time flew.
Yeah.
Yeah. So especially when you got life, and if you're the executor of an account or of an estate administrator, and you have a family, you're still doing normal day-to-day life, and like, oh yes, and I have to take on this huge, administration of mom's or of the estate, family's
Exactly.
estate.
Yeah, I
It's
mean,
a lot of work.
Yeah, life goes on for you, but
Yep.
you have the added grief, trying to go through the grieving process after having lost a parent or grandparent, whoever it is, all of that added on. And then all of a sudden you go, oh, wow, we have to move forward with the estate, and 7 months has passed.
Yeah.
So it does.
This is something I'd love to learn more about. So guardianship, kind of moving on. So we talked about the planning, talked about post-death, kind of what happened, but also you mentioned this term guardianship several times. What is guardianship? Can you simplify that concept?
I can try.
Okay.
So guardianship is, well, first I'll start by saying we have around 2,600 open guardianship cases in Summit County, between 24 and 2,600. And each one of those cases, the court has determined that a person can no longer make decisions for themselves because of some illness, injury, perhaps drug use, mental illness. They have some type of infirmity that doesn't allow them to make decisions for themselves. The thing that we see most often and what we always think about is Alzheimer's or dementia. We have an older parent, that has been diagnosed with Alzheimer's and can no longer make decisions for themselves. So we as the probate court are the court that handles those cases, and we appoint a guardian to make decisions for that person. So that process can be a very difficult process for the family, emotionally especially, and actually it leads to arguments and fights as well, because both kids believe they're the best decision maker for mom, and so they both want to be guardian. So if there isn't a power of attorney in place where mom said, hey, I want it to be my daughter, I'm the guy, or Judge Stormer, one of our other magistrates, is the person that decides between those two people who's going to be guardian if both of them apply. Again, just reiterating the importance of having those powers of attorney in place. I'd much rather have you decide than me decide for you who it should be. But it can't just be I'm walking in off the street and I'm saying, hey, I think my mom needs a guardian. You have to have a statement of expert evaluation from a doctor. So a doctor has to examine the person and say, because of X, dementia, this person can no longer make decisions for themselves, and they need a decision maker in place. So we have to have that written statement from a doctor, fill out a full application, what job do you have, what are your qualifications, assets, have you ever filed bankruptcy? They fill out that full application to show that they are suitable to be appointed guardian with that statement of expert evaluation. And then they also have to list family members, because in Ohio, everybody's entitled to notice of that guardianship. So if there's two siblings and the one sibling files, the other sibling gets certified mail showing that someone applied to be guardian. And in Ohio, thankfully, the potential ward gets notice of it as well. So if I file for guardianship of my mom, we have 3 court investigators at our court. They go out and talk to the potential ward and say, hey, your son filed to be your guardian. Here's what that means. Are you okay with that? And then give them a notice of when the hearing is. So we have somebody go out and talk to the ward and say, this is what's going on. Are you okay with it? And the potential ward can say, yes, I'm fine with it. I trust him. I'm okay with him being my guardian. And then we move forward with appointing them. Or they can say, no, I don't need a guardian, or I don't trust him to be my guardian. And then at that point, it moves into a full-blown evidentiary dispute. And those are hard. Because in those hearings, you have a son sitting there saying, hey, my mom needs a guardian, and here's why. She's incontinent, can't take care of herself. She gets in the car and gets lost. All of these things show that she needs somebody to be a decision maker. And that's hard to do, especially when your mom's sitting there, and listening to it. So those hearings are difficult. And so we always treat those, with the deference that they should have. So it can be a difficult process. There are safeguards in place, like I just talked about, but it's basically that person can't make decisions, and they need to have somebody there to do it for them.
Mm-hmm. Wow, it feels like 2,400 to 2,600 is a lot of open cases. Now, with that number, you mentioned some of them could be even younger age, maybe a drug abuse situation, or someone needs to care for someone that's incapable of caring for themselves.
Developmental disabilities.
Okay, so who tends to file that? Is that so developmental disabilities could be a parent filing on behalf of their child. Drug abuse could be a parent filing. But if this is a person that's really unknown, that's just kind of out there in the community, that can a neighbor file? I mean, how does that happen? Does somebody raise a red flag and say, hey, I don't think my neighbor's capable? What is the process for someone that really doesn't have family local, that might just be on their own?
Yep, and that does happen a lot.
Does it?
Yeah, you're right. Oftentimes it's a family or a friend. People from church. A lot of times we'll see they have issue. They see that the person's starting to have issues, and they may take the step to do that. Unfortunately, we get a lot of guardianship filings from like adult protective services, where we have somebody who's being abused, neglected, or exploited. They don't have family around. APS is involved, and they'll say, wait a minute, this person needs to have a guardian, and then they would find an attorney or whomever to file that guardianship with our court for that person. Hospitals as well, nursing homes. Somebody gets taken to the hospital, they don't have a family member, and the hospital goes, wow, this person has dementia, whatever the case may be, they need a guardian. So they'll have an attorney file for guardianship, try to find family members, and if they can't, have an attorney file to be guardian, or have the attorney try to find somebody. And also in Summit County, we're lucky. We have a company, they're called Adult Guardianship Services of Summit County. They used to be called the Volunteer Guardianship Program, and it was a court-run program where if someone didn't have a guardian, the hospital, the nursing home, APS could call the court, and we would find a guardian for them that was a volunteer. When I was in practice, I did that. I was on the list. I was probably guardian for, 30 to 50 people probably over my career, maybe more, maybe less, but somewhere in there, where they didn't have somebody. So they needed somebody, so they sent it to me and asked me to do it. A lot of times that was, free because they didn't have assets, and sometimes they did have assets and I would get paid. But now we have the Volunteer Guardianship Program. They're an independent company, 501c3, where I know they have contracts with some of the hospitals and nursing homes and APS, where they can send them those referrals, and then Adult Guardianship Services will file the application.
That's a whole nother world that I don't think most of us know exists out there, but there is a need for our communities to care for people in that way.
Without a doubt, and I know they're always looking for people. It's volunteer guardianship services, so it's people that have volunteered. A lot of times it's a social worker at Hickory Ridge, for example, just pulling a nursing home out of my mind. She's a social worker during the day, knows there's a need, so she'll be a volunteer guardian for a couple of people. Can't be at Hickory Ridge, but a couple of people maybe at another facility or that live at their house. So there is definitely a need for people. If people are looking for volunteer opportunities, that's definitely, I know, an entity that could use help.
So if I'm going to volunteer for such a thing, like I'd imagine like if an attorney is appointed as a guardian of someone, is the attorney actually like compassionately being there by their side and helping them with things? Or is it like, hey, I'm representing their legal decision making? And also as a volunteer guardian, is that a different role? Or are they also acting as like a decision maker for that person? You know what I'm saying? Does that make sense?
Yeah,
Okay.
absolutely.
I'm like thinking like, was an attorney really going to be like, hey, I got 20 of these guardianship cases right now in my practice. It feels like it's a lot of like sitting by the person and just kind of helping them along with things. Maybe not. Maybe I'm misunderstanding.
No, there is some of that.
Okay.
You know, there are minimum things that you have to do. One, you have to see your ward at least 4 times a year.
Okay.
And obviously attorneys probably see their wards less than the volunteers do. I know the volunteers at Adult Guardianship Services, they have to see them, I think, every month. So they spend more time with them and get to know them a little more. But as a guardian, yeah, I mean, you're the one making decisions for them. I've had to make those decisions for people that were strangers to me. And that was always difficult. You know, I was guardian for a ward who had COPD, and it got to where the disease had progressed to the point where it was like, should we put her on a ventilator or not? She didn't have family members, you know, the doctors. So me as the guardian, I'm the one that said, here's what you're going to do, and signed on the dotted line, because that's what guardians do. Whether it's an attorney, a volunteer, a family member, you know, a neighbor, whomever, that's what you're charged with. And those decisions can be difficult. But I've had to make those decisions for people that I didn't know. So the way I did it, and I hope that most people do it this way, is you got to get to know them a little bit so that you know what it is they would want. Yep. The lady that I'm talking about, we had that discussion. She said, this is what I would want when this happens. And, you know, so that's what I did. But yeah, you're the one charged with making those decisions, and whether you're an attorney or a volunteer or a son, yep. you're held to the same standard.
Yep, got it. Yeah, guardianship is something I've always heard of. In fact, I guess we can transition to like real estate, because we've had some cases where, you know, an attorney is appointed as guardian over as an individual, and they have an estate that needs to be moved, mm-hmm. right? And I think of one particular case of a hoarding situation, and it's like, okay, you know, hey, we need to sell this person's property, and real estate can be complicated. Why is this so complicated in the state? What is up with real estate? Why is it so
because
hard?
of realtors. No, I'm just kidding.
That's right. That's
real
right.
estate always has issues, I guess I'll say. And one of the reasons on the estate side, so when somebody passes away, with real estate, the moment somebody passes away, title to that property transfers to whomever it's supposed to transfer to. So if there's a will that says, Steve and Darrin, get the property 50-50, when that person dies, we're now the owners 50-50 as soon as they die. Whether a deed or a certificate of transfer has been recorded, when those things get recorded, we're just memorializing what has already happened. So in that situation, if Steve says, I don't want this, I want you to have everything, I can't do that unless there's a disclaimer process you can go through, a legal disclaimer process you can go through. I'm not going to start talking about that because we'd be here another hour. but that, you know, that's the process you can go through, because again, title vested when that person passed away. So there's only certain things you can do to not transfer it to whom that title legally vested in. So I know that's kind of a complicated concept. But yeah, we're merely memorializing what has already occurred when we record that deed after somebody dies. Okay. It's already done. We're already the owners. So I can't just say, hey, never mind, I don't want it, I'm giving it back to you. We would have to transfer it to the two of us, and then I could sign a deed transferring it to you. But that's the process we kind of have to go through. A lot of people get mad at us for those reasons, and it's not our fault. You know, that's title law. Title law says that's what you have to do, and you know, title to real estate you have to have that chain of title, etc. So that's one of the biggest things I think that leads to real estate being difficult. And then obviously you have mortgages, liens, taxes, the upkeep of real estate that make it difficult in an estate. You know, as this estate's pending and the house hasn't been transferred yet, who's taking care of those things? You know, in an estate setting, hopefully the estate has money to pay those bills. And if they don't, who's going to do it? And that's, I think, what makes real estate kind of a difficult proposition, is the expenses that come along with it.
I see that. We see that often, that statistically, what we've seen or what we've heard, like this research, I don't know if Summit County, you guys are dealing so much with individuals. I don't know if you guys have like broad data, but 80% of the value of an estate is in real estate. That's what the research says. I don't know if it's different here in Summit County.
I'd say easily, yeah.
So you have an estate where a significant chunk of the value of that estate all mom had was the property, right? So,
Right.
so now we need to deal with this property, and that's where the money is sitting. We've seen that people want to get the money out of that house as soon as possible, and they want to sell it immediately. Like, why can someone not sell that home? Sounds like because of some title issues, but like, okay, now let's pretend we're, mom passes, we're the children, and you get the property 50%, I get it 50%, and we want the money out of the property. How soon can I get my money?
Oh, that's a great question. How quick is your executor acting? Obviously, before any of that can happen, if we're talking about a probate estate, so it's not a transfer on death, it's a probate estate. You have to file the estate paperwork. We have to provide all the notice we're required to provide. So if it was a two-person situation, for example, and you're both saying, hey, we want to get rid of this thing as quick as we can, you can sign waivers of notice, which cut down on time to serve. So if I file a will, I have to serve everybody who's named in the will and all of the next of kin of that person. So if they have 4 kids, I have to send certified mail to all 4 of those kids, letting them know that Steve filed that will for probate. So that takes time. Once the person's appointed, they have to file the inventory. So the inventory, again, tells us what's going to go through probate. With us, once that inventory is filed, you can sell the house. If there's a will and the fiduciary has power to sell in the will, they can sell it the moment that inventory is filed. In fact, I've approved it before the inventory was filed in certain situations, like if they had a contract to sell it and then the person passed away before the contract was completed, where I've approved sales even before that. But those situations don't come around a lot, but it can. So if you have waivers from everybody and you get that inventory filed, you could sell the property at that moment. So it could be a couple of weeks, honestly. What happens a lot of times is, the estate doesn't get filed for a couple of months. They don't have waivers from everybody, so we have to send certified mail before we can appoint somebody. Then that person gets appointed, and then it takes that person weeks or months to figure out what the assets are before they can file that inventory. So, now we're talking about months of time has passed while the house is sitting there. So that the moment that inventory is filed, you can transfer that house.
But typical situation is it does take a few months.
Yeah, typically. I mean, we do have, I just had one, so in Summit County, we call it a real estate only transfer. So if the only asset is a piece of real estate, and the person wasn't on Medicaid, 6 months after their passing, so it takes at least 6 months, 6 months after their passing, you can file, I'll call it, for lack of a better term, an abbreviated estate that basically says, Dad's only asset was a house. Here's all the next of kin that are entitled to inherit the house. Here's the waivers where everybody signed off saying, we're good with this moving forward. They file that packet, and we'll issue a certificate of transfer within a couple of days to transfer the house to whomever it was that was supposed to receive it. But again, you have that 6-month creditor claim period that we have to be careful of and always be cognizant of and protect, because the statute says we have to. So you still have to wait that 6 months. So that's usually where the catch is the creditor claim.
We've seen some issues on transfer on death. I think it's great to have that in place on your real estate property. Transfer on death, it goes to your 3 children, and each kid now all of a sudden wants to do something different with it. One kid wants to buy the house for themselves. One person wants to use it as a rental property. One person wants to sell it, get the cash out of it. Like, how does the probate court handle disputes like that? I did a good job of filing a transfer on death, or that designation there. Okay, so now my 3 kids get it. I'm done. Right. I die. My 3 kids get it, and then now what? There's disputes among the kids. Is that something that the probate court would administer or would handle, or how does that typically work?
It is not.
Okay.
So
okay. Good.
If it's a transfer on death affidavit, and you have kids fighting over what happens, that's actually in the general division. It would be a quiet title action in the general division. So if you have those 3 kids who are fighting over what's going to happen with it, they file a lawsuit in the common pleas court and say, court, what should we do? and then the court makes a decision. Oftentimes it's sell it and split the money, or if he wants to buy it, let him buy it, for fair market value and then split the money. So that's not actually us. If it's a transfer on death situation, it goes to the general division and not us. But that is absolutely, when I was in practice, something I advised people of and told them that exact situation. Son wants to buy, daughter wants to rent, other son wants to sell it. What's going to happen if your kids say that? What is it that you'd want to have happen? And most of the time they go, well, my kids don't fight. And then I would laugh and say, till there's money involved. But I always wanted people just to think about it. Is there a situation? Do you know there's going to be a situation? If so, don't use a transfer on death affidavit for those. Put in your will, I want the house sold and the proceeds split between my 3 kids. And then we at the probate court make sure that that's what happens. It wasn't transfer on death, it's in the estate. Now you lose that ability to transfer it immediately because you're going through the estate process. But if you know there's going to be an issue, you're protecting hopefully your kids from that coming up.
We see personal property holds people up, they get stuck, right? So prepping the house for sale. You might have approvals to sell the house.
Right.
But then it's we all need to go in there and clean all this stuff out.
Right.
We've even had people we'll say, hey, we'll come over, because part of our services are coming to help move the personal property, right? So whatever they need to do with it, whether estate sales, valuables, retransfer, retitle things, or just move it to junk, right? Throw it out. Families are embarrassed to bring us in because they're like, oh my gosh, the way Mom was living her final years, nobody really knew how bad it was, and so people get stuck there. Any thoughts or any advice on people with their personal property? Have you guys seen that in your court as well? Any thoughts or advice on
a lot
how to help families?
Yeah,
with
for
that?
sure. I mean, we've seen where the biggest thing obviously we see is people arguing over who gets what.
Oh, yeah. Okay.
So obviously a will helps with that, and hopefully the will is specific as to divided equally between my 3 kids. Here's how I want it done. Not all wills say that, and then there's been disputes. Hey, we've agreed on everything, but all of us want this one thing. And then we would have a hearing and try to determine what to do with it. So it does happen with us a lot, and I'll say that I think oftentimes delays in filing estates are because of that. The house is hoarded, or, Mom had all this stuff. What are we going to do with all this? What do we have to do? And, if people are arguing over it, that's when it's difficult. If everybody's on the same page, the beneficiaries can say, let's get a dumpster and, pitch the stuff we don't want. If there's anything worth value, worth anything, let's sell it, or whatever the case may be, and move forward. But personal property can be difficult, as you know, can be very difficult to deal with.
So you said sometimes they have to go to the court and say, hey, how do we distribute this clock or whatever, right? I think of my parents' grandfather clock, and my brothers joke around about who's going to get it, right? And so this clock, let's pretend we all fight over this clock, right? Is that something? It's so minor. It's maybe $1,000 or something like that.
Exactly.
A couple grand or whatever. At what point is the court just okay, guys, we're kind of wasting time, wasting court resources, wasting money? Is there such a thing as that? Do people dispute over one tiny little thing?
The longest estate that I ever dealt with in practice was 5 years.
What?
It was a brother and a sister who literally fought over everything. The estate, 5 years later, literally got down to a hope chest that had Afghans in it.
Okay.
And they argued about that until the end. We filed me and the attorney that represented the other beneficiary filed a motion asking for a hearing for the court to determine what was going to happen with the hope chest.
Yep.
Thankfully, my client finally goes, let her have it.
Okay.
I'm tired. Just let her have it. But yeah, it happens. So if there's a huge dispute over something like that, you probably have to have it appraised. Okay. To know what the value of it is, see if you can equalize the distributions with the other beneficiaries some other way. Hey, you get the clock that's worth $2,000, you get $2,000 more in liquid assets. Try to see if there's a way to work it out like that. If not, we would have a hearing and try to determine what happens with it. Mm-hmm. Sometimes we might say, you get the clock. Oftentimes we would probably say, sell it and split the money.
Sure. Yeah, it's kind of the easier way to do it. It's not emotional, but in those situations, the heirs are hey, this is so important to me. It remembers. after 5 years, it's almost like the emotion should be gone. Hey, I can't put myself in their situation, but it is a long time to have to deal with that.
It is, and that's
worse
where my
than some
client
divorces.
Yep, exactly. In the civil world, we would have called that litigation fatigue.
Okay.
He's tired of fighting.
Yep.
So he said, I'm tired of fighting. I just let her have it. And that's, that's where he was.
That's great.
Hey, Darrin.
Yeah.
It seems to me that in estate planning, maybe the first step is to be a good person, to be decent, to be good to people, teach your children well, so that down the road, some of this is avoided, right? Like step number 1, don't be a jerk.
Be a good parent.
Be a good person.
Oh, that's so, yeah.
Be good, be the kind of person that just exudes peace and civil relationships, right? Like, of course, that can't be put into a plan necessarily. It's just like, does that make sense?
Absolutely, it does. And I think that people that are taught that at an earlier age are probably less likely to dig in and fight over things like this. Obviously, it's not foolproof, but yeah, I think that all of us have those things that were instilled in us by our parents or grandparents, whomever. And I think that if you have that foundation, you're probably less likely in the end to fight over that grandfather clock. But yeah, I mean, I agree with that for sure. And I think that I wish everybody had that attitude. I guess if they did, though, I might not have a job. So.
Yeah. It seems like, like in today's world, like we almost live in this like IKEA type world where my parents really invested in beautiful furniture and this, my mom, I remember growing up, just loved this Amish furniture, and she would get a custom hand-built Amish furniture. And today it's like, oh, we'll go to IKEA and get it for $100. And it's like,
exactly.
And so
we'd assemble it ourselves, and there it is.
Yep. So this value, like, I don't know if it's a value, like a belief on where are our values. Some people would rather have assets in maybe some antique furniture. Other people just want cash or whatever experiences. So it's interesting to see, like, generationally, I believe there's less things of value in our home than there was in my parents' home. Like, yes, we have furniture. Yes, everybody has a bed and everybody sleeps in a bed, and but I don't have this custom hand-built Amish, masterpiece or anything, right?
Exactly.
So it's interesting to see that, and it's like, and values, as you mentioned, Tim, like, just like, how do we instill this? Just interesting. The whole thing is we're dealing with people, we're dealing with lives, we're dealing with emotions.
Exactly. And I think one of the things I know we kind of talked about earlier, that was like what 3 things would you say to somebody when it comes to planning? Yeah. Think about it. Think about what it is you want, who you want to be in charge, who you want to get your stuff. If you're incapacitated, who do you want making those decisions? The second thing, actually do it. Get the plan done. Yeah. Thinking about it and telling your kids this is what I want isn't enough. If everything isn't going to be distributed equally between your kids, and all of your kids are yours and you're not married, you have to have something that says what you want to have done. Get that plan done. Get those powers of attorney executed. Think about it, do it, and then last, and we kind of talked about this before we went on, communicate. Tell your kids this is what you're doing. Tell them this is what my plan is. Tell them, hey, Steve, I didn't name you as power of attorney. I named your sister. She's a nurse, so I want her to be able to make medical decisions for me. Talk to your family about it. It's not easy. None of us want to think about it because we don't want to think about being able to make our decision, right? And not being alive. That's hard things to think about. And talking to our family about it is even harder. I've had clients say, hey, I tried to talk to my kids about this. They didn't want to talk about it because they didn't want to think about me dying. All of those things are real and true to life things. But if you have that communication piece after you have it in place, I think it helps alleviate some of the issues that might come up, especially if there's hard feelings over like an unequal distribution of property. Interestingly, the estate I was talking about was 50-50 and they still fought over everything. And that communication doesn't necessarily mean they're not going to argue, but if they know what's coming, they're not blindsided, with what's going on, or why was Steve named and not Tim, as the attorney, in fact. If Dad talked to you about it, I think it kind of helps prepare you and let you know what's coming.
Yeah, that's expert advice. Think about it, do it, and communicate it.
Exactly.
That's good.
Yeah.
So anything, we could probably talk for hours about this. This is your passion as well, but like anything we haven't talked about that we should have discussed or brought up for that curious citizen?
I can't really think of anything. Tara, are there any questions that we normally get that you think we didn't talk about?
I feel like you guys have covered.
You know, one thing I will talk about, we kind of touched on it, but let me expand just a little bit. Transfer on death, payable on death.
Okay.
I mentioned that whoever's named on those accounts, or if it's a transfer on death affidavit, you can do a transfer on death title for your car, by the way. Whoever's named gets that property, period. Make sure you know who that is, and that's who you would want it to be. If circumstances change, make sure those things are updated. I had a case with a guy a couple months ago where we handled what we had to handle during the hearing. Afterwards, we were just kind of sitting there talking, and he said, you know, after this happened to my dad, I made sure I went to my bank and set up a transfer on death for my kids. So they weren't here dealing with this. That's when most people figure out they should do something. And he said, I went to the bank and I named my 3 kids. He goes, and then a couple weeks later, I went back and said, you know, who did I name as my beneficiaries? And they said, oh, we have both of your kids named on there. Well, he had 3 kids, and they only had 2 of them. So even if you think you know who's there, make sure who you think is there. Go to the banks, check with the life insurance companies. Make sure that the beneficiaries that you think are getting it are actually who's named. And remember that does trump your estate plan. So if you have that transfer on, so another thing that I know you've seen in the title world or the real estate world is survivorship deeds. So a survivorship deed is usually with a husband and wife. Doesn't have to be, but usually. And that survivorship deed is Steve and Ann own this house for their joint lives remainder to the survivor of them. I walk out of here today, I get hit by that Coke truck like we were talking about earlier. My wife gets my death certificate, fills out an affidavit that says, he was my husband, we own this jointly, he's dead, here's his death certificate, signs it, notarizes it, files it, the house is transferred to her. So that happens like a transfer on death affidavit, same process. I name my 3 kids, I get hit by that truck, they go in, fill out that affidavit, house is transferred to the 3 of them. I always use my dad as an example to this. So my dad owned an 84-acre farm just south of Canton. That's where I'm from originally. And I come from a blended family, just like we talked about earlier. My dad was diagnosed with brain cancer back in 1999. And when he was diagnosed with brain cancer, he did what most people did. He got his estate planning done. He was 52, but didn't have his estate plan in place until he was diagnosed with this illness. Well, in his will, he said, I want my kids to get 50% of the farm and my wife, my stepmom, to get 50% of the farm. What my dad didn't know was he had a survivorship deed. So when he died, the farm transferred 100% to my stepmom. So me and my 3 sisters didn't get 50% of the farm. My dad didn't know that. So make sure what you have in place, is actually what you think it is. Check those things out. If you have an attorney, ask those questions to them so that those things don't happen to you. For me, luckily, I'm still in touch with my stepmom. We're still close. I just had Christmas dinner with her, last week. So I think, things are going to turn out okay for us. But that is definitely not what always happens. Sure. Usually a step parent gets it. I shouldn't say usually. Sometimes a step parent gets it and, the kids are out of luck. So just make sure those things, if you have those in place, you know what they are.
Mm-hmm. That's really helpful. We mentioned my mother-in-law passing. We had one situation with a beneficiary. That one account wasn't named, even though it was in the same, same brokerage, account. But anyway, the one thing I thought of is like this. The world of AI, the world of online advice, the seeking truth, how do people actually like online legal services? People are like, oh, I don't need an estate planning attorney or financial advisor. I have this online app that I'm using to create my will. And are these types of online documents, are they seen as real legal documents by the courts?
It depends.
Okay.
Love it. The thing I always tell people, obviously, wills.com, all
Sure.
these companies out there, or you hop on Google. Will from Ohio form. And this form pops up, you fill it out, you sign it, you have 2 witnesses witness it, which is what you have to have here. 2 witnesses witness a will. It can be notarized, but you still have to have a second witness. So it has to have 2 witnesses signed at the end, et cetera, et cetera. But what you don't know is the will that was pulled up was actually a Pennsylvania will that might just have a notary on it instead of the 2 witnesses. And if you don't know that, you could have what you think is a valid will and it's not. So the online services are there, and I think some of them are good, some of them aren't. One is very popular right now. I don't know what company it's from, but I probably have had 4 or 5 of them come across my desk so far, the same exact will. And it says, if I die, I want my property distributed to first beneficiary, name, second beneficiary, name, third beneficiary, name. And people have it filled out. Well, does that mean that the first beneficiary gets it all? And if they don't, it goes to the next. And if they don't, it goes to the next. Or does that mean it's split equally between the 3? The document doesn't say. So if the beneficiaries want to fight about that, they file a will construction case with us, and then I decide what that will means. So yes, I think they can be used, and I think some of them can be effective, but be careful, because there are pitfalls and issues with ambiguity and improper execution and things like that that you don't even know happened, and you're gone. And then there's nothing we can do to fix it. So yeah, they can be used, just really be careful of the source. To me, I would spend the money that it takes to spend to get a full estate plan in place to make sure those things don't happen and all of my stuff and I am taken care of the right way.
Yep. Yeah, that makes sense for a small investment or a big investment. In some cases, like you have it done right. Hopefully,
exactly.
That's good.
Well, and to me, at the end of the day, with my estate plan, what do I care about? Of course, I want my stuff to go who I want it to go to, but I want it to be easy on my family.
Yep.
The last thing I want is to do something unknowingly that causes an issue for them. Hopefully they've liked me enough that they're grieving when I pass. Yeah. And they're dealing with that. And the last thing I want them to have to worry about is, oh wow, Dad's will isn't effective. Mm-hmm. So sometimes it's worth that expense to make sure the people that we care about, it's easier for them. I mean, to me, that's the goal. What's easier for them? I want to make sure that what I want to have done happens and make it as easy on them as it can. Maybe they won't care when I die, and that doesn't matter.
I like to hope that our kids will care about us when we're gone. Right. That's good. Yeah, I think, again, this is so helpful. If I'm a curious citizen, I would want to know how this works. Should I be intimidated by it? Like what are the ins and outs of it? And hopefully you don't have to deal with it that often, right? Sometimes people maybe only deal with it once in their lives, and then they give advice to all their neighbors and friends about how it went. And so, we really are, from what I hear, very lucky and blessed to have a great court here, probate court here in Summit County. And I think you guys are doing a great work, and so hopefully, as families file, they can be more confident and comfortable with your team and in Judge Stormer and the processes that are there. So,
well, thank you. I definitely appreciate that. Like I said, we strive to do that, and we want to continue doing it. So thank you for saying that. I definitely appreciate that.
Yeah. Really appreciate you being on. Yeah, thanks for and hopefully this will educate a lot of people, a lot of families. So
yeah, it was great. I appreciate the invite. It was great.
Yeah,
hey, Darrin, I've got a question that might go nowhere. Do you read a lot?
Every day.
Of the things do you read the things you want to read or the things you have to read?
Both.
Okay.
Yeah.
There's a book I read a few years ago by Hernando de Soto called The Mystery of Capital, Why Capitalism Works in the West and Almost Nowhere Else. And something interesting, this is basically a setup for the question. What I found most fascinating about it was that if capital is the blood that keeps capitalism alive, the heart that pumps it is title. Title, because it's universally accepted in the nation, is the thing that keeps all of this going, right? So if you took title out of the equation, an example, if I have a title for a property in Medina County, but in Summit County they don't honor that title, that's a big problem, right?
Right.
And that's what happens in most of the rest of the world that tries this economic system and it falls apart. If that's the case for title, what would happen if there was no probate? If there was no probate, what is that then causing catastrophic failure for? If you could just, off the top of your head, like what do you think would happen?
Oh, that's a great question. I think that if there wasn't probate, I think there would be chaos. I think that we would have title to real estate, cars, whatever, never knowing full well who the actual owner was, which in a capitalistic society, in order to be able to transfer that property, we have to know who the owner is to be able to transfer it to whomever, whether it's by sale or whatever. So if you didn't have probate or have a system in place to ensure the proper person has title to that property, I think that it would cause our economy to grind to a halt. I mean, because, you know, as we're in a capitalistic society like you're talking about, what makes it happen? Capital. And if I don't know if you own it or Tara owns whatever it is, how can I have confidence that I'm paying the right person for it? So if you don't have a court that looks at, here's who owned it, but here's who owns it now, and here's the seal that proves it, I think that I think chaos would ensue.
So is probate the mechanism, the primary mechanism for making sure that title is preserved in its integrity, or is there some other mechanism within the judicial system?
I think probate is probably the primary mechanism at this point still. I mean, like we talked about earlier, you still have the transfer on death and payable on death transfers that happen outside of probate. And that happens with real estate, accounts, investments, all of those things. So that does happen outside of probate. But I think at this point, probate is still probably a majority of where property passes. I know when I first started practicing back in '03, even before that, when I was a law clerk in 2000, not everybody used or was comfortable using TODs and PODs. They had transfer on death deeds came about in Ohio, I think even after that, and it turned into transfer on death affidavits. So I think that those things are catching on, and a lot of those mechanisms are being used more and more as people become more comfortable with them and more aware of them. But I still think that at this point in Ohio, I still think probate probably passes a majority of property from generation to generation.
That's cool. I think of some situations just like what people said. Like you used an example earlier, and an example, an actual real life example in my head of like we were contacted by a sibling or about an heir that said like, "Hey, mom said that I was going to get the property, and I need your help." And I'm like, "We're not attorney. We can't help with legal stuff, right?" But come to find out, the sister was the executor and was given the property and sold the property, had the right to sell the property, but this sibling wasn't there. So like in a situation like that where probate didn't exist, like how would that, like that would have been, like you said, there's some of the chaos.
Right.
And that could be, it's an interesting question, Tim. Like
it is.
Think about that. If probate didn't exist, what would things look like?
I know that the general division wouldn't like that because they'd have to handle all those lawsuits without a probate court.
Yeah, that's true too. Yeah. And I have over 200 different kinds of cases and, thousands of guardianship things. And it's interesting. I love how you put it at the very beginning, new beginnings and new endings. And so that's a good way to wrap up what the Summit County Court does.
Yep.
Out of all the things you do.
Yep, exactly.
That's cool.
Yeah.
Anything else, Tim? Yeah. Tara, anything?
I actually thought of something. Our website is very user-friendly. So
It
if
is.
you're a listener right now and there's been terminology and things you've discussed and people are overwhelmed hearing all of this, it's a good place to start. I mean, you can learn so much about how to prepare and what to do by visiting our website. It's really easy to get around. I mean, wouldn't you agree?
Oh, absolutely. And I'm not, well, I guess I am going to brag about our court a little bit. I've actually had magistrates in other courts say, I've referred people to your website because we have set it up in such a way to try to help people to be able to do a lot of these things on their own and or just to have that information if they have an attorney. So you can get on there and it's set up that you can literally look at the adoption process, the guardianship process, the estate process, those different types of estate processes. releases and the real estate onlys and full estates. We have everything laid out, when you can use it, what forms you need to fill out to be able to do it, and just general information. And we even have forms, power of attorney forms, living will forms on our website. All of those things are available. So definitely, as a member of the public, if you have questions, take a look at it. I think it'll give you some good guidance.
Great. What is the Summit County Probate Court website?
SummitOhioProbate.com.
Yep, SummitOhioProbate.com.
Okay.
Everything's spelled out.
Okay. And then if you mentioned earlier, hey, these little like Probate 101 conversations, if anybody out there has an organization that they might want these types of conversations, how would they get a hold of you and your team? Is that also through the website?
Take a look on the website. Who they would contact is actually Tara.
Okay.
Tara is our community outreach person.
Okay.
So her information's on the website.
Great.
Just contact her and let her know. We ask that you have 20 or more people at the presentation, if you can, so that we can reach more people, and we'll get you on the schedule. I think at this point we're probably scheduling into May or June, probably, because we do have quite a few requests that come, which is great. The more people that know, the less people have issues. Right. so it's a good thing. But yeah, give us a call, give Tara a call, and we can try to get you on the schedule as quickly as possible.
Wonderful.
Is there a cost associated with that?
There's not. We actually do it for free. So like I said earlier, we're not allowed to give legal advice, but to a large group of people I can speak about the issues in probate that might come up.
Sure.
And we can do it anywhere from 20 minutes to an hour, whatever it is that your group is willing to sit through.
That's right. Yeah, cool. Well, thank you so much. Again,
Absolutely.
it's great.
Yeah, thanks for having me.
Yeah,
appreciate it.
Yeah, you
Yeah.
bet.